Welcome to Legal on Demand, powered by Maguire Legal, conversations on law, business, and the decisions that matter. I'm Sonia.
And I'm Eda. In this episode, we're discussing a topic that can become incredibly disruptive for businesses very quickly: managing director conflict.
And this is one of those issues that generally starts quiet. It might be a disagreement about strategy, finance, operations, or decision making that gradually evolves into something much more serious.
Particularly in founder led businesses or closely held companies, where directors are often deeply involved in the day to day running of the organization.
Most people think that director conflict only becomes a legal issue once proceedings start, but usually the warning signs appear much earlier.
It might begin with directors excluding each other from decisions, disagreements around spending, concerns about transparency, or breakdowns in communication between the leadership group.
And once trust deteriorates, it can impact the entire business, spanning from employees, operations, customers, to commercial relationships as well.
What's important is that directors are not just business owners or decision makers. They also have legal obligations under the Corporations Act 2001,
Exactly. Directors have duties to act with care, diligence, and good faith, all in the best interest of the company, and avoid improperly using their position or information.
One thing we often see during conflict is directors start to act emotionally or personally rather than focusing on the company's interests. And these duties become particularly important once conflict starts emerging because directors can sometimes lose sight of the distinction between protecting their personal position and acting in the best interests of the company.
Under the Corporations Act, directors are required to exercise their powers and discharge their duties with care and diligence. They must also act in good faith and in the best interest of the company and for a proper purpose.
Which means directors can't simply make decisions based on frustration, personal disagreements, or internal politics.
No. Even during significant conflict, directors still need to make decisions objectively and in the best interest of the company itself, not in a way that disadvantages one faction, shareholder group, or individual director.
Another issue we see is misuse of company information during disputes.
Yes, the Corporations Act specifically prohibits directors from improperly using their position or information obtained through their position or role to gain advantage for themselves or for someone else, or even to cause detriment to the company.
That can become particularly risky where directors begin withholding information, accessing confidential material for strategic leverage, or communicating with staff or clients in a way that damages the business.
Exactly. And once trust breaks down, directors sometimes forget that their obligations continue even if relationships within the leadership team deteriorate.
There's also a misconception that because someone is a founder or majority shareholder, they can simply make unilateral decisions outside proper governance processes,
And that's not necessarily the case. The company structure still matters. Board processes, constitutions, shareholder agreements, and delegated authority frameworks all continue to operate regardless of personal relationships.
which is why governance becomes so critical during director disputes.
Once decisions stop being properly documented, meetings stop occurring formally, or directors begin acting outside of authority, the legal and operational risk to the company increases very quickly.
That's where legal exposure can start to increase significantly. That distinction is really important because a disagreement between directors does not automatically justify conduct that harms the company itself.
Directors can disagree strongly on strategy or management, but they still need to continue complying with their statutory duties.
Once conflict escalates, we sometimes see directors withholding information, blocking access to systems, making unilateral decisions, or excluding another director from management discussions.
Which can create governance issues very quickly, particularly where there's no shareholder agreement or dispute resolution framework in place.
This tends to become especially difficult in small and medium businesses where directors are also shareholders and operationally involved every day.
Because the business relationship is highly personal. In many cases, the directors founded the business together, built a client base together, and made the decisions informally for years.
And then once a relationship breaks down, the lack of structure becomes a major issue.
One of the biggest operational risks is deadlock. This is where directors are unable to agree on key decisions and the business effectively becomes stuck.
That can impact multiple aspects of the business, including staffing decisions, supplier payments, business strategy, financing, and even day to day operations.
At that point, the dispute is no longer just a personal conflict. It becomes a commercial risk to the company itself.
Another issue that often arises is access to company information.
Directors generally have rights to access company books and financial records in order to perform their duties properly.
But during disputes, we sometimes see one director attempting to restrict access to emails, financial systems, or operational information.
And that can create even greater legal and governance problems because directors are expected to properly inform themselves when making decisions.
One aspect people underestimate is the impact director conflict has on employees.
Staff can quickly become caught between competing instructions, uncertainty around authority, or inconsistent managing directions.
Which can create workplace culture issues when this trickles down to the employee level, operational confusion, and in some cases, employment law risk.
Particularly where employees are pressured or presumed to take sides in internal leadership disputes.
A lot of these issues become much harder where governance documents are weak or missing entirely.
Exactly. Businesses often delay putting proper governance structures in place because relationships are positive at the beginning.
No one expects anything to go wrong when things are positive, but that's actually when those documents matter the most.
Things like shareholder agreements, dispute resolution mechanisms, delegated authority frameworks, and clear decision making processes can significantly reduce risk if conflict arises later.
So, practically speaking, Sonia, what should directors do once conflict starts emerging?
Well, the first step is recognizing that early conflict management is usually far less expensive than allowing the dispute to escalate. That means documenting concerns properly, maintaining professional communication, and avoiding unilateral conduct, and focusing on the company's interests rather than personal grievances.
And importantly, directors should avoid making reactive decisions that may later be viewed as breaches of duty.
One of the biggest misconceptions is that directed disputes are purely internal matters.
But in reality, they can affect business continuity, financing, employees, customer reputation, and long term enterprise value.
And once litigation starts, the operational and financial impact can become very significant very quickly.
The key takeaway is this: director conflict is not just a relationship issue, it's a governance and risk issue.
Exactly. Directors still owe duties to the company, even during conflict. And businesses that put proper governance structures in place early are usually much better positioned to manage disputes if they arise later.
If your business is experiencing leadership conflict or reviewing governance structures, obtaining advice early can significantly reduce legal and operational risk.
Follow Legal on Demand for more conversations on employment and commercial law.
Thanks for joining us on Legal on Demand. Practical law, real decisions on demand.